Hey everybody, good morning. I'm JD Houvener, your host of the Bold Today Show. You've made it. This is a live Q&A forum with myself, a patent attorney, and I've got a special guest for you as well. This is a half-hour broadcast. We're going to be doing live questions and answers. Anything about patents, trademarks, intellectual property is fair game. Today's major topic is about assignments of patents. What is an assignment? Why would you want to do that? And when would it make sense in the context of starting a company, or if you own a company already? I'm excited to get to that. I'll be posting here a legal notice. I am an attorney after all, even though I'm doing this goofy live video with you here today. And this is being broadcasted across YouTube, Facebook, and LinkedIn. So welcome from all three channels. But that legal notice does say don't share confidential information. By nature of you joining the broadcast, you're not my client, okay? This is not a confidential session. I will be providing a link if you do want to have that later. We have a great website where we can schedule you for a screening session to see if we're a good fit, to see if our firm is able to help you at this time. So welcome those live viewers, good to see you. If you're a first timer, please give us a like. We want to share this across all platforms and get this audience as big as we can. This is our ongoing, probably our second year doing this. We've got our main trademark attorney on as well. I see him backstage, Matt Kolseth. We'll bring him on, and as well as our special guest. If we do have time, we're going to get to Avo questions. Avo.com is where I volunteer, and our firm volunteers to answer questions from around the country related to patents and trademarks, and maybe pop in a few fun questions on the business side too. If we run out of things to talk about with our special guest, I highly doubt that. So again, we'll be prioritizing live questions and answers, live questions that is, and giving those answers as soon as we can. So without further ado, I will be bringing on our guest, Dan Nguyen. Dan, welcome to the show.
Hey, JD, thanks for having me.
Absolutely. I'm excited to have you. It's an honor to have you. So Dan, you are the owner at Dan X Group. Is that right? Am I saying that right?
Oh, just law office of Dan Nguyen.
Law office of Dan Nguyen. And you're based in California, and you guys practice in business law. Is that right?
Yeah, correctly. We do business, so entity formations, we do franchising, and then we also do trademarks as well.
Perfect. Well, that sounds good. When we're going to get to some questions for you and learn more about your firm. I'm going to bring on Matt Kolseth. He's with our crew. Matt, good morning.
Hey, morning, fellas.
Hey, Matt.
Looking clean shaven today. Nice, dapper outfit. I'm feeling really underdressed.
No longer mustache November, December, etc.
Yes, I like it. Dan, you too, of course. Looking sharp. Anyway, I'm trying to get away with this T-shirt over here. Good morning, Justin Wykerzek. Sorry for mispronouncing that, Justin. Welcome to the show. Fire with any questions you have, Justin. We're here for you. This is why we're doing this. So Dan, you may know, but Matt is with our firm. He's with Bold. We've been doing this show. I've been bringing him on as a co-host the past this year, so it's been great. We do trademarks in-house, so I know you're doing trademarks over there at your firm, but you're going to be able to add a lot of cool insight. We're learning about ways that companies are starting, how you move intellectual property from you as the inventor, as the creator, the artist, to a company. And as you start a company, what are things to think about, right? If you want to own it forever, do you want to keep it yourself, or when does it make sense to assign it to the company? Walk us through that, would you?
Yeah, sure. So, when I have a discussion with my clients is like, who do you want to own these particular intellectual properties? It can be very complex depending on what their ultimate goals are, or it can be very, very simple based on, what they really need right now, and just to kind of keep things moving. So, if you've ever read the book, 7 Habits of Highly Effective People by Stephen Covey, one of the things he talks about.
Yeah, I'm not sure if I made it all the way through. I might have gotten 3 or 4 of those habits. Yeah, I got to get back to it.
I think the 7th one was finish the book.
Right. Dang it. Okay.
Not the first habit, but the 7th habit.
I'm on it. All right.
Think about the end in mind. So I think for a lot of business owners, when they start a business, they actually should have at least some semblance of an exit strategy as they get in the business, right? So a lot of people say, I want to work forever, which is fine. But whether you execute on working forever or selling, I think you should have a plan in place to get an exit. right? And so,
Man, that's kind of rough, right? Thinking about the end before you get started. That's tough. I like that advice, actually. So why would someone want to do that?
yeah. So, it's the fundamentalism, or the fundamentalism really is it kind of goes back to the goal setting, right? It's like, you're going to start this thing, right? There is eventually going to be an end, whether it's for you or the business or whatever. And so, if you don't have it kind of a target in mind, then it's really kind of hard to steer the ship ultimately where you where they want to go. So kind of going deeper, right? It's like, within the intellectual property, are they looking to get royalties afterwards, right? Or
Okay.
are they looking to sell the IP along with the business? Sometimes companies sell just merely for like the distribution system and not any of the intellectual property. Sometimes the companies sell just purely for the intellectual property. And so with kind of those big things in mind, then they can plot how to strategize their holdings too. And also, if they want to receive royalties, right? So I actually was talking to a CPA, and we were talking about trademarks, and the question was, it was kind of really of a discussion question. If I apply for a trademark for my firm, can I own it as an individual, and then have my
So you're
company?
talking about for your office, your law office?
This was actually for a CPA I was having a discussion with. It wasn't
Okay, yeah, got it.
yeah.
Got it.
So their question to me, and I thought was pretty good, was, hey, I've got this trademark. If I hold it in my own name, can my company, my corporation, my LLC, pay me royalties for the use of the name? And as far as I know, it was perfectly fine. There was no, I looked into it, but there's no tax benefit, right? So she's paid the same income tax. But I think that's kind of a larger strategy that a lot of the bigger tech companies use. I've heard, I don't know this particularly, but they'll hold their company in Ireland or Virgin Islands, where it's really really low taxes, and they say Amazon, for example, and I'll caveat, I don't know if this is actually true, but just because everyone knows Amazon, Amazon buys and sells, and makes the revenue off e-commerce and AWS, right? But they have a IP holding company based in, say, Ireland, and 90% of the revenue that they make in the United States will be used to pay a royalty to the entity in Ireland. And so effectively, Amazon may, or any big tech conglomerate, pay very little U.S. taxes. And so again, I don't know if this is true or not, but I think that's the particular strategy that these large company makes. And so obviously with smaller companies, you may not have the resources to do all this, but I think it's the strategy is something to think about if you're thinking longer term. If the business owner is in the day-to-day business, that maybe they're looking to step out, but still want to get some particular royalties as they go into retirement, or they go into another business venture, they can still collect them by either having a separate IP holding company and collecting those royalties separately.
Okay, cool. And Matt knows me. I like to use really funny examples. And last one, I think it was 2 weeks ago, I was on Fizzy Soda. Okay, so Fizzy Soda, they're coming back. Brand new, made up company name. They, the owner, sole operator of Fizzy Soda, he came up with the name Fizzy. And there's a cool, it's got a color to it. It's got some interesting little bubbles around the logo, Fizzy Soda. So just to make sure anybody's out there doesn't understand what assignment means. So that individual sole practitioner, they're running a company, they're selling, they're making soda and selling it on the streets or something. And they file for and they get a trademark registration. Matt's laughing. They're on the street. I got a backpack full of Fizzy Soda, buddy, and this is my registration. I'm interstate. I'm going between the bridges. I'm interstate, so I'm going to file. All right, and I know it's funny, but hang with me. So here comes a business partner. I think this is the future in Fizzy Soda. I want to invest in your company. So but you bring them on as a business partner. The concept is that you will assign, right? Bob, the owner of Fizzy Soda, who's been backpacking, he's going to be assigning his rights in Fizzy Soda, the registration, to Fizzy Soda LLC or Fizzy Soda C Corp. That's an assignment. So my question is, you're talking about royalties. I want to make sure that's clear. So would an example of that be where after a couple of years of wild success, Fizzy Soda is now a 300 employee company. There is a new startup cola company, and they want to be able to use Fizzy in their branding. They want to take a license in the word Fizzy, and or maybe collaborate with you, and they have a coffee soda, and they want to be able to use your name in their branding. Is that the kind of thing you're talking about in terms of making money with a royalty, or were you thinking of something more simple?
Yeah. Oh yeah, no, that's a perfect example, right? And this is kind of the hypothetical world, right? So I guess I remember, JD, you're a PE, so similar to like what is it called? Ignore friction, right? Ignore the descriptiveness of business, right?
Right. Yeah, that's right.
But you're exactly right? Yeah, that is something that part of the monetization process, or one of the avenues of monetization of trademarks, can be licensing to a third party to use that name for their ventures. Yep.
Okay. And when you were talking about, I was researching before this, I was trying to find the answer. I'm going to share my screen here, and this might get a little bit wacky, but that's okay. So I'm going to share my screen, and I was looking up a invention, because I do that in my spare time. This is augmented reality imaging. This patent was granted just a few years ago to a company I think I've heard about, Microsoft. But what's interesting is, you're right. This is not Microsoft, the big Microsoft. This is this Microsoft Technology Licensing LLC. And there's 3 different categories. There's the applicant. The inventors are actual humans. So there's 7 people that invented this invention. They assigned their rights to the invention, likely because they had to, because their employment contract, to Microsoft Technology Licensing, which I'm sure is owned by, perhaps, well, I'm not sure, but by your hunch, owned by a company maybe incorporated in Ireland, right? For tax purposes. Is that the concept? Is that what you were getting at earlier?
Yeah. It's obviously, we don't have the actual, knowledge, but I think it's
right.
It's a very popular strategy to have to do by very large companies.
Mm-hmm. Yeah, and I think it can be at least part of this, like you said, this exit plan, this broader plan, to maybe have assignments like this. Well, you may not have 7 engineers working for you. Maybe you have 1 or 2, or there's a couple of co-inventors who will make sure that you assign it to your company, your LLC, that someday you might be able to restructure or form a way to be tax advantageous to the owners or shareholders. Awesome. Matt, any comments on things you've seen from our clients you've helped in the past related to assignments of trademarks?
Yeah, no, this is a really relevant topic, and everything Dan said is 100% on the mark. So thanks, Dan, for sharing your expertise with our viewers today. Yeah, from our perspective, in terms of the clients that we work with, typically we're working with smaller to medium-sized companies, startups, entrepreneurs, inventors, that sort of thing. The question that we get a lot is, I have an LLC. It's just me at this point. But I'm thinking about bringing on partners. Would there ever be a reason why I would own the trademark application as an individual, as opposed to having my LLC own it? And the answer is yes. There would be a reason that you would be interested in that potentially. For the most part, we would encourage clients to register the trademark under the ownership of their company, whether it's a corporation or an LLC. But for sometimes some clients are interested in separating the two. So they'll own the trademark registration as an individual. And then when they bring on partners or sell the business, they have to basically negotiate that trademark assignment separately. The one thing I see clients sometimes miss when they do that strategy, like I said, there's a valid reason for doing it, is technically they should have a licensing agreement between them as an individual and their LLC when they are actually using the trademark. That would be best practice. And we encourage clients to do that. We do that for clients routinely, but I sometimes see clients miss that step. So from my perspective, yes, clients will do it occasionally. There has to be a specific fact pattern in order to encourage them to do that, though.
Cool. And Dan, have you helped owners of IP set up those types of agreements before?
Yeah. So a lot of the work that I've done is in the franchising area, because if you know anything about franchising, one of the elements of a franchise is a trademark, and typically there is a federal registration or federal application in place in order for the franchisor to essentially sub-license it to a franchisee. And in those particular structures, usually there is a separate company that owns those particular trademarks. So there needs to be I'm sorry, not an assignment, but there has to be a licensing agreement between the trademark owner and the franchisor. However, I come across setups where they've got like one or two corporate stores, or maybe even or more. Their trademark is held in one of the entities that owns one of the corporate stores. And so what we recommend is we have a separate entity merely just to own the trademarks. And so there will be an assignment from the current owner to this essentially IP holding company.
Cool. That's right. That's nice. So if there was, a bunch of companies that were located at all of the bridges that go between states, and there's companies, and these are soda companies, they want to have backpack soda sales, they could be a franchise group across the nation. And so FIZZY corporate would assign their trademarks to FIZZY holding company. FIZZY holding company would then would be a part of a licensing agreement to the various companies at all these bridges, and they would be able to use FIZZY in terms of their sales.
Correct.
That's cool. That's awesome. Thank you for sharing that. And because you mentioned franchising, I didn't catch that initially. So you do quite a bit of that. That's nice. Thank you for that. There's a lot that we could talk about. What I want to do is just give you a little bit of press. Flavio, good to see you. Yeah, I'm glad you're enjoying the live. I want to make sure people know how to find you. So your website is dxnguyen.com. Is that right? The best place for them to get to you after looking online?
Okay. That is my website. The best, if you want to learn more about me, I actually have a YouTube channel where there's a bunch of videos there. So it's called, what is it called? Legal Tips for Smart Entrepreneurs. So I've got a bunch of videos on YouTube. So everyone kind of want to see what I'm all about, they can see all my videos there. Yep. And then if they
Legal
want to
tips for entrepreneurs. Okay.
Yep.
That's cool. Yep. Thank you for sharing. I'm gonna look that up. We'll post that or if you're able to post it here while we go to our next segment, please do that in the comments. For anyone that would like to speak with us, if you got an invention idea, if you got a trademark you want to move forward with, I'm gonna provide you with a link here. It's a special live link, so our folks will know where you came from for a free 20-minute screening session. Again, this is no cost. You're going to be able to see if patenting trademark protection is the right thing for you. If you're a business owner and you've got questions about business law, Bold Patents is not the right place to go. You want to go visit Dan and his group over there at Dan X Nguyen Law Firm. He's going to provide you some cool insight. If you want to just go learn about some stuff, he has some great YouTube videos to watch as well. So look for him to post that in the comments too. So Dan, I'll put you backstage. We're going to go to a few questions on our avlo.com group. And if we have some time, we'll maybe quizzing you, putting you on the spot with some business law questions too. So thank you so much for joining. We'll visit you in just about 5-10 minutes.
All right.
All right, Matt, just you and I. That was cool having Dan on. We're going to have him back. He's got, I've never talked to anyone about franchise. I have about 100 questions about franchise law.
Franchise, it's very cool. I've had the pleasure of working with lots of franchisors and franchisees over the years, but yeah, having someone with that kind of piece is super.
I should have just asked you, man. I guess that's a funny thing. No, you don't really know.
I know little about the nuts and bolts of franchise agreements and things like that. I just know that franchisees and franchisors love trademarks.
Yep. Absolutely. All right. So I'm looking at the Avlo here. We got one question on trademarks. Come on, people. This is out of Vegas. I was in Vegas for a consumer electronics show. So this question's out of Vegas. Let me get the full question. It's a t-shirt question.
Oh, my favorite.
We love t-shirt questions. Okay, I'll put this in the comments.
Class 25. Here we go.
You already know. Okay, here we go. I'll pop it in here. It's going to cover up our faces for a second, and I will read it off. Okay. Need help, please. How do I trademark something? I have a T-shirt I made a year ago with a funny saying on it. And while I was walking with some friends, who also thought that was funny, that's nice, somebody took a video of me wearing it and posted it online. This is cool. The video was shared in over 800, is that million times? And even used on a Comedy Central show. Wow. Called Tosh. I've heard of that. Yeah. How do I trademark my shirt, or at least the saying? Is it too late? Please help. Wow.
Yeah, well, that's a lot of views. Maybe they
800 million. Okay.
Maybe, but yeah. So yes, you can certainly trademark a phrase on apparel, with the caveat, with several caveats. So yes, a phrase can be trademarked for apparel purposes. It's class 25 at the USPTO, but there's a number of things that have to be, required. First and foremost, the phrase would actually have to act as a trademark. It wouldn't be necessarily a trademark if it was just a saying that was either just funny or ornamental, if it didn't act as a trademark. Trademarks are typically small, right? You're talking 1 to 3 to 4 words potentially. And they act as a brand, so they identify the source of the apparel. So they connect that product to the mind of consumer through a trademark, through the branding. A slogan doesn't necessarily do that. The USPTO would typically say that, not a slogan rather, but this phrase would typically say that phrase is merely informational or merely for entertainment purposes and not acting as a true trademark. The other thing to know about applying for trademarks for apparel is the USPTO is very particular about how we prove that the proposed trademark is actually a trademark and not merely informational, entertainment purposes, right? They want to see that phrase, that trademark, in the upper left breast pocket area of a t-shirt, polo shirt, sweatshirt. So they're very specific with where they want to see it, because if you put that phrase across the front of a t-shirt, they're going to say that that's merely ornamental and not acting as a trademark. So they want to see it where you would typically see a traditional brand, like a polo symbol.
Yeah, I'm trying to find my shirt here. I don't know if I got one. No, sorry. Yeah, it's a Costco brand. Yeah, so that's all right. I don't know where's mine. I hear you, Matt. That's great.
Yeah, so that's
got some sort of thing here.
Yes. So yeah, that would be.
There is that on the sleeve, right? Okay.
So the USPTO would say that would be more traditional branding placement. So we get a lot of inquiries from potential clients who might have applied for a trademark themselves in the apparel class, and they have an office action, which is refusal at the USPTO. And the refusal is typically for a bad specimen, or the proposed trademark is merely educational, informational, entertainment purposes. But I guess the largest one is probably they have their proposed trademark in big, bold letters across the front of the shirt, and the USPTO says that's not proper specimen. So we basically will encourage them to, hey, the USPTO really wants to see that logo right here.
Yep. Okay. How about this concept of maybe that they're trying to get at sort of like a privacy law, or, hey, I want to get credit for being on this, nobody from Comedy Central, let me know. I don't know. Is there anything there? And maybe we'll bring Dan on, see what he's got. What do you think on this? We'll bring Dan back. He's probably
bring Dan back. But I would say personally, no, unless they're monetizing it and selling their own version of it, and that could be a potential issue from a copyright or trademark perspective.
Dan, I should have just kept you out. I don't know why I put you backstage. Sorry about that. We needed you the whole time. Yeah. What are your thoughts on this one?
Can you posit the question again?
Yeah. So this guy's got a T-shirt he made a year ago, funny saying on it, and someone took a video of him wearing it, and it blew up on social media. He says 800 million views, and it may be a little exaggerated, but it was also featured on Comedy Central's Tosh 2.0. How do I trademark my shirt, or at least get some credit? Yeah, they want money for being on a video that was seen on major TV. Thoughts on that?
Yeah, so I think Matt hit it the major point in the head, right? For a lot of clothing brands, a lot of people or entrepreneurs make kind of the mistake really just to put it on the chest, right? And that's where they really get held up on getting a registration, because it's as we know, the requirement is either on the hang tag, or maybe a plastic bag, or the neck tag. But I think the other issue also is he may not come into this because it's kind of new, but if like famous phrases, right? I actually was going through this with another matter. It's like famous phrases cannot be protected. I think LeBron James tried to do Taco Tuesday a couple of years ago, and he got denied for that.
Oh,
And
man.
so,
Yeah, that's a bummer.
well, good for everyone else, right? It keeps Taco Tuesday for us people. So,
Yes.
but my guess is he kind of just made this up, right? So it's not, I don't know, 800 million views. Maybe it's famous now. So he might
there's something to it.
Yeah,
Okay.
he might have something to that. But I mean, kind of based on what we know right now, his best shot probably would just probably do a hang tag, or probably a plastic bag, right? Package bag on it. But
Okay.
yeah, couldn't get it. Just the phrase itself, unless one other thing I was remembering, if you're a basketball fan, so I'm from Southern California, so of course I'm a LA Lakers fan, right?
Okay.
So in the 80s, there's the coach in the 80s, Pat Riley, who was their coach, and he coined the phrase three-peat, right? Around that time, I think they won 2 championships. They were on the verge of winning 3. They got into the finals, lost to the Detroit
Pat
Pistons.
Riley was with the Lakers? I think Pat Riley, I think Miami Heat.
Yeah. So everyone knows him with the Miami Heat. But in the 80s, he was their coach for their back-to-back titles. In the late 80s, he coined the term three-peat, and he actually owns, or his company owns, the trademark three-peat for like phone case covers and several other stuff.
Okay.
Right? Okay. Yeah. So that's how you get the trademark. But I think very similarly, it has to be not ornamental and cannot be a famous phrase. Yep.
Good stuff. Thank you, Dan. All right, we have time for maybe 1 or 2 more questions. This one is very random. I was looking through I guess we ran out of trademark and patent questions. This is out of Monrovia, California. I know you're California-based. This question is pretty interesting and pretty straightforward. People maybe living at home, people underage, minors. The question is my mom allowed to keep my money from me? I don't know how much we can get into this, but I thought we'd just throw it at you, Dan. I want to start investing. Mom is keeping all my money. I'm 17. Got any help for this guy or gal?
Oh, that's a tough one. Yeah.
Yeah.
I mean, I'm not. I guess this would be family law, maybe. I don't even know what this says.
Category.
Yeah. But I mean, even if you wanted to, if you want to do traditional investing, through Fidelity or Charles Schwab, if you're 18 and under, or you're under 18, you still need what's called a custodial account. So you still need someone who's an adult to open that account for you. And so I don't know how unless you have someone else, all right, an adult, but that doesn't solve the problem of you actually getting the money. So honestly, unfortunately, I don't know this particular answer.
Fair. Yeah, I didn't either, other than just probably not is the answer. Hey, you're not 18. 18 is legal age. That's all I know. Hey, but fair enough.
Unless he wants to try for emancipation, but that's kind of like the nuclear option, which is basically separating himself from his parents and declaring himself as a adult, I guess. Yeah, that's
okay.
Yeah.
Thank you for jumping on that kind of wild question. I got one more wild one for you, just because I like them. And here we go. Someone wants to starting up a hookah business, where I go to people's houses and set it up. Do I need a tobacco license? Custom places, they order for hookah. I go to their house, get it set up, depending what package they choose. What licenses do I need?
Good question. So I would first, do you need a tobacco license? I would first see if the local hookah lounges require a tobacco license. And if they do, it might be, those licenses are probably just for serving on premises. So you would need to talk to your city or your county who issues these licenses and basically ask them, hey, this is what I want to do. And then they can tell you that either yes, you can do it, or no, you can't do it.
Right. But your hunch is that they probably would need to get the same amount of licensing as if they had a place of business that people came to.
Yeah,
if they're going to their customers.
Yeah, because I'm gonna liken it to alcohol, and as far as I know, there's no As far as I know, there's no businesses that will come to well, I guess if you're one of those ad hoc bartenders, do they need a license? So yeah, I'm not sure. So that's what kind of I'm analogizing, this particular hookah business too. Yeah.
Totally. Okay. I'm going to squeeze one last one in. Yeah. Justin Weigerick was listening earlier. He asked a live question here. So since you're speaking of clothing, can you have a company name, for example, the King's Crown? Could you make clothing line that just has the word King printed on it if someone else has a trademark that is the King or King? So kind of printing on the shirt versus having the actual brand.
Is the question for me or Matt?
Yeah, well, it's kind of for everybody. It's kind of go ahead. Whoever wants to jump in. I mean, we're free for all. I would give you the floor since you're the guest here, Dan. So it sounds like someone owns a trademark for, let's say, apparel for the King. Okay, they own that trademark for apparel, and can someone else, ABC shirt company, can they put the King printed in an artistic or maybe even a scripted format right on the shirt? Would that be an infringement?
Matt, you want to take a crack at it?
Yeah, sure. I'll take a crack at it. So, so I think there's like two questions here. One is they have a business that's called the King's Crown, and that might be the name of their LLC, or maybe that's the name of the website. So that's a potential trademark right there, the King's Crown, if they're using it in a trademark sense. Maybe if it's the online store, it's called the King's Crown. That'd be a Class 35 application to protect the online retail store sales. And then the second question is about, King, using that as a trademark if somebody else has already registered the King or King in Class 25 for apparel. And I would say that King would be a violation of the King registration at the USPTO. So 2 points. One, the USPTO wouldn't allow you to register King if the King is already registered, because it's too similar. It presents what they call likelihood of confusion. And second, you might be in violation of the person who's registered King's trademark rights and subject to a cease and desist letter. So I would say that that would not be a good trademark. But of course, I mean, I'm happy to jump on a call with the potential client and kind of walk them through that and dig into it a little bit more. Perfect.
Thank you, Matt. Good deal, guys. We're going to wind down the show. We had a lot of good questions come in. Dan, thank you so much for being a good sport and taking those live questions and walking us through patent assignments, IP assignments, and giving us just a little taste of franchise law, which I think I'm going to bring you back on the show to talk about. So again, for all of us here, our guests, I wish you guys a great day. If you missed us on our broadcast, we'll be here next week, 9 a.m. Pacific, noon on the East Coast, for the Bold Today show. I'm JD Houvener. I wish you guys have a good day. Go big, go bold.